Welcome back everybody to the Law of Tort. In this video what we're going to do is move away from looking at psychiatric harm as a sort of subsidiary harm that can be claimed in the tort of negligence, and instead moving on to talking about the next of these kinds of harm and discussing the general rules relating to pure economic loss as well as consequential economic loss as well. We're going to spend a little bit of time talking about pure economic loss and consequential economic loss in these couple of lessons, and then we'll also spend some time talking about the concept of negligent misstatement, which sort of bridges the gap between the cases that we look at in the law of tort and the cases that we look at in the law of contracts. So the Headley-Byrne principle, for example, is one of the key examples of this. And then from there, if we just do a basic roadmap on the case of negligence, we'll talk about the standard of care and the breach of a duty of care in the next few lessons after that, and then get on to thinking about causation, both causation in fact and causation in law, i.e. new intervening causes and the concept of remoteness. So that's sort of the roadmap for the next few lessons on negligence, and then we'll start to talk about various other types of tort that can exist in this area of law. Previous lessons, as I've mentioned, examined different kinds of damages which can be derived through the concept of psychiatric harm. We talked about the concept of psychiatric harm being an element of damage that is attributed to a physical injury or economic damage, for example. We then also talked about what is known as pure psychiatric harm, the idea of there being a harm that is caused, and it is only psychiatric. It is not a physical injury, it is the development of a psychiatric condition. This is divided into both the concept of the primary victim and the secondary victim. That is what we've focused on in the last few lessons. This lesson is going to talk about how the law is applied to pure economic loss. Okay, so what is economic loss and what is pure economic loss? Well, economic loss, as the name suggests, is loss to some kind of financial position or some kind of financial loss. So, for example, if you were to be injured at work as the result of some kind of negligence, let's say that there is a cleaner decides to clean the floors and they don't make it very clear that there is a wet floor. You go along and you slip and fall and you break your leg. Let's say then that you therefore have 6 weeks off work because you can no longer work because you have a broken leg. The concept of economic loss is the concept of the economic loss that you would have suffered as a result of having that time off work. Maybe you have you only managed to get a certain reduction in pay as a sort of compensation for you being off work, as in like sick pay, for example. And so as a result of which you've lost money. Okay, that's what economic loss is. What is pure economic loss? Well, as the name suggests, pure economic loss is not damage which can be found in physical or psychiatric injury of a negligent act. Instead, it is derived from the failure to gain some actual profit which may be had in the future. Now, just like pure psychiatric injury relates to the idea of developing only a psychiatric injury as the result of negligent action, and not one that is complemented by some kind of physical injury, pure economic loss is the kind of idea of developing an economic loss and only economic loss as the result of negligent action, and not economic loss which is in conjunction with either damage to property or physical injury. Okay? So, if someone, if as the result of some negligent action, you were to lose money, okay, could you claim for pure economic loss? Okay, that's the question. Now, this is more than just economic loss, because economic loss is the result of physical or psychiatric injury or damage to property, okay? So there is actually some kind of physical damage or psychiatric damage that is caused to an individual, and then there is a loss that is consequential to that. That is what is known as consequential economic loss, which we'll get to in a future lesson. We're talking here, though, about economic loss in and of itself. There's no physical injury, there's no damage to property, there's no psychiatric injury. You just lose money as the result of negligent action, okay? Can you claim for that money as a result? Well, the general rule is that economic loss, which is not attached to some kind of actual physical damage or injury to yourself or to property, for example, the general rule is that that kind of economic loss is not recoverable in tort. The general rule for pure economic loss is that there is no claim for pure economic loss. There are two general rationales for this rule. The first is that the concept of economic loss is something which is traditionally subjected to the remit of the law of contract. If you lose out economically as a result of some kind of action on the part of another individual, then in the law of contract there tends to be some kind of remedy for your loss that you have essentially been suffered or had suffered to you. This is the general rule, and so as a result of which, the rationale is that this is traditionally the remit of the law of contract. The second rationale is that there are policy implications. There is namely a floodgates issue following claims for pure economic loss. Because if the general rule was that you could claim for pure economic loss all of a sudden, then there would be a floodgate of litigation, because there could be a near infinite expansion and duplication and multiplication of various different claims that could be made. So let's get into some of the cases. We'll finish by talking about the case of Weller and Co. Versus the Foot and Mouth Disease Research Institute from 1966. In this case, the defendant was the Foot and Mouth Disease Research Institute, and they had negligently let out and allowed the spread of foot and mouth disease. Okay, a particularly nasty illness, not particularly very nice. The result of this spread of illness was the quarantine of cattle. Okay, something which caused the claimant, who was Weller and Co., the auctioneer, to lose out on money. Okay, so essentially what had happened is that there was a disease that was spread, and this disease can affect quite significantly cattle. And so as a result of which the claimant was the auctioneer of the cattle, lost money because they had to quarantine the cattle to stop them from getting this disease. Now, the question here is, can the claimant successfully claim for economic loss as a result of the negligent action, the defendants negligently letting out and allowing the spread of foot and mouth disease? Well, if we think about it, then we can see that this would fall into the remit of pure economic loss, because essentially what the defendants had done is that they had quarantined the cattle on the basis that they were fearful of those cattle getting the disease. The disease did not actually reach this particular collection of cattle. They only lost money because they couldn't sell the cattle. They couldn't auction it off because they had to leave it in quarantine. So there was no actual damage to property, i.e. because cattle is considered property in English law. There is no actual damage to property here. The only thing that was damaged, or the only thing that was lost, was the ability for the auctioneer to lose money. And so because the loss was only loss incurred to profit, there could be no claim in the tort of negligence, because this would have represented pure economic loss. If there had been damage to the cattle, if the cattle had actually caught foot and mouth disease, then there might have been a claim, because then that would have represented damage to property, and then there would have been the death of cattle, which would have led to a loss in money, which could have represented consequential economic loss. But because there was no damage to the property, they would just had to be basically quarantined for a bit, and the auctioneer lost money on the basis that they couldn't sell that property. Then there was only ever pure economic loss, and so there was no claim. So, as I've mentioned here, if the claimant's cattle had actually become ill as the result of the negligent spreading of the disease, then this could have led to a successful claim in negligence, because there would have been a physical damage there, because the cattle had actually become ill. The fact that they hadn't become ill meant that it was only ever pure economic loss. So in the previous lesson, what we did was talk about the concept of pure economic loss, and we established that the general rule for pure economic loss is that a claimant cannot bring a claim for pure economic loss. This lesson is going to talk about the concept of consequential economic loss, and the ways in which and varieties of claims that can be brought as a result of this particular claim. And we'll talk about some of the case law in relation to this area as well, but we'll also be talking about some of the implications and delineations between pure economic loss on the one hand and consequential economic loss on the other. So this is really a lesson about the distinction between pure and consequential economic loss, the ways in which you can claim for consequential economic loss versus the ways in which you can't claim essentially for pure economic loss. We'll be examining and illustrating the view of consequential economic loss with some interesting case law on the matter. The main case is going to be the Spartan Steel case, which I'm sure for most people that's not going to be a surprise. It's pretty much the landmark case that you have to know for this area of the law. And so as a result of which, we'll get to that at the end of this lesson. So consequential economic loss is essentially distinguished fully by the courts, since when we remember from the previous lesson, when we talk about economic loss which is pure, then there is no available claim. So, for example, if I was to, as the result of negligence, have suffered some kind of loss to profit, there is no physical damage, there is no physical damage to property, there is no personal injury, there is no psychiatric injury, anything like that. There is just a loss in profit for whatever the thing is that I have done. That would be considered pure economic loss, and there would be no claim available to me for that particular negligent action. Consequential economic loss is slightly different, though, because as the name suggests, consequential economic loss is consequential on the claimant's damage, which is caused in the negligence to their property or to their person. So, if we take the previous example and we say, okay, well, we have loss to profit or loss to income or whatever that is economic in nature. But let's just say that instead of that just being in and of itself and on its own, let's say that that loss to income or loss to profit was the result of damage to my property or damage to myself, personal injury damage or psychiatric harm that's caused me to, let's say, have 3 weeks off work and therefore only manage to get sick pay, and so as a result of which have a lower income. This is what is known as consequential economic loss, because it's consequential on the damage that is caused by the defendant's negligence in to their property or to their person or whatever. So if you are injured as a result of a negligent action, then this injury means you are unable to work for many weeks. Then the consequential economic loss, in addition to the ordinary damages that you may be able to recover from the negligent action causing the injury, the consequential economic loss will pertain to the economic hardship as well as the loss of income from your inability to work your job. So that's what consequential economic loss is, and as you can probably imagine, there are far more avenues for bringing a claim in consequential economic loss than there are for pure economic loss. If you have suffered an injury or damage to property as the result of negligent action, remember, all of these cases, whether we're talking about economic loss or whether we're talking about psychiatric injury, require you to have shown that there is negligence in the first place. You have to have a duty of care, breach of duty of care, you have to have causation in fact, causation in law, remoteness, etc., or a lack of remoteness, should I say, etc., etc. And so as a result of this, assuming that you can provide for all of these different circumstances, assuming you can provide for all these different ideas of negligent action, and that there is economic loss that is caused by the damage to either yourself, personal injury, psychiatric injury, or to damage to your property, for example, then the basic test is just the duty of care standard that we have examined in previous lessons. It is then therefore represented as a type of economic loss which is very similar to any other kind of damage that is caused by negligent action. So, for example, damage to property which causes economic loss could be negligent action caused by a car accident, where the car is therefore unusable for many weeks or even is written off entirely. If you rely on your car to drive to work, and for the work itself, for example, let's say you have a company car or your work involves you traveling around the country, let's say you're a door-to-door salesman, then you will also suffer an economic loss as a result of the fact that your vehicle has been damaged, has been written off, or it has to go and be fixed. All of these different things contribute to this idea of consequential economic loss. Now, over the years, the courts have had to work quite hard to be able to delineate between a loss which could be recoverable in tort, which would be consequential, and loss which is not recoverable in tort, i.e. pure. And you might think, well, surely it's very easy to understand, it's very easy to see, but not in every circumstance and not in every situation is it easy to reconcile or even make the clear delineation between a certain amount of loss that we would describe as pure and therefore no claim, and economic loss which we would describe as consequential and therefore an economic claim could potentially be brought. So one of the illustrations of this case, is the case of Spartan Steels and Alloys versus Martin from 1973. And you will see when we look at the facts of the case in the next slide, that this is actually quite difficult to reconcile. And I would encourage you to pause before we look at the judgment to try and see where you would stand on this particular issue, and where you would stand on where the pure economic loss is and where the consequential economic loss is, or where the consequential economic loss ends and where the pure economic loss begins. So this was a case where we have the claimant who is the owner of a factory. Now, the factory would rely quite significantly on the use of electricity, as you would probably imagine, and so as a result of this, when the defendant in this case negligently drives over some power cables, these power cables supplying electricity to the factory, there was a significant power cut which lasted for around 14 hours. So the factory had no power for around 14 hours. This is quite annoying, given the fact that this is Spartan steel and alloys. It says they're allows, but we're talking Spartan steel and alloys. Where essentially this is a steels factory, okay, and so as a result of which there are multiple instances of damage that are suffered by the factory owner. So, because the factory itself was a steelworks, and it relies on molten steel and quite significant and quite hefty industrial equipment, what they had to do was, because this was a steelworks and there was molten steel in some of the machines, they had to remove that molten steel from the machines before they would solidify and be unusable. Okay, this all was a result of the negligent action, because there was no electricity to actually continue the molten process of creating steel. I don't know how it works, but I'm not a chemist. Otherwise, the steel would have caused damage to the machinery if they hadn't have removed it. So the removal, this removal specifically, this set of claims would reduce the value of the metal itself, because they would remove the molten steel at an earlier time than they should have done, which caused the metal to have less value than if it had been essentially worked to completion. The melt itself would have been profitable, but this profit was also lost. There was also future melts in the process which would have been completed but for the electrical power cut. So really the question that I would like to ask the people who are watching, and for you to pause and consider, is, of all of these different kinds of damage and different kinds of loss which were claimed, which ones were successful and which ones were potentially not successful? You have melts and steel that was removed, which lost value, okay? You also have the melt itself, which would have been profitable, but that was lost. But there was also, because there was a 14-hour power cut, there were future melts that were not completed because they couldn't have been completed because there was no electricity. Okay, so which of these actually could have made some kind of claim? Well, the courts held that the first claim, i.e. the reduction in the value of the metal, as well as the second claim, the profits from that single melt, were both examples of consequential economic loss, and so as a result of which some damages can be claimed on those bases. Because of the fact that these were damages to the property itself, i.e. to the metal itself, there was damage to it, owing to the fact that the negligent action by running over the power cables supplying electricity to the plant, it meant that these could be consequential in nature. However, the rest of the claims, so for example the claims for future melts, these constituted pure economic loss, and so as a result there was no claim available. The reason why was because these were future melts, and these were just the loss of profits as a result of losing out on potentially having electricity in the future. These weren't anything to do with the specific damage to the properties, which was the case in the first melts. So this illustrates very nicely by the courts the distinction between a consequential economic loss, which is the consequence of damage either to oneself, to one's property, to psychiatric harm, etc., 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 and pure economic loss. There was no damage that was caused to anything in terms of the future melts. There was just a lack of ability to cause to have those future melts in the first place, and so as a result of which these were pure, and therefore there was no claim. Over the last couple of lessons, we've been talking about the concept of pure economic loss, and concluding that the general rule for pure economic loss, that is loss that is only economic in nature, it is not attached to any kind of damage that is either physical, psychiatric, or maybe damage to property, that the general rule for pure economic loss is that there is no remedy available, there is no claim available. We then talked about the distinction that is made between pure economic loss on the one hand, where there is no claim available, and consequential economic loss on the other hand, where there can be a claim available. And consequential economic loss is, of course, loss which is consequential, as the name suggests, onto some kind of damage that is caused, either physical injury, maybe psychiatric harm, or even damage to property. This lesson is just going to talk about the development of the pure economic loss principles in a bit more detail, and we'll talk about some of the cases that have arisen out of these ideas, where we're looking at, for example, the case of Ans and Merton on one hand and Murphy and Brentwood on the other. So the previous lesson specifically talked about the Spartan Steel case, where we made a clear distinction between this idea of pure economic loss and consequential economic loss. In fact, the Spartan Steel case is one of those rare instances where such a delineation is very, very easy to show, because there are lots of different instances where the claimants tried to make claim for loss, some of which were consequential and so therefore were successful, others were not consequential, they were pure and so therefore they were not successful. A very nice case that's neatly illustrates all of these different points. We're going to talk about two more cases in this video, and the reason why we're going to talk about two cases is because we want to show that the difficulty that the courts have had in actually making these delineations between pure and consequential economic loss. The Spartan Steel case made it look easy, because you have some instances where you have certain melts and certain steel that were of less value, and so were directly damaged by the negligent action, the cutting out of electricity on the main road. But then you also have instances where they tried to make a claim for future melts that had no specific damage attached to them, and so they were considered to be pure economic loss. So that distinction was made to look easy in the Spartan Steel case, but the delineations and determinations between these two different types of loss, economic loss specifically, aren't as easy to actually show. Ultimately, it's not always clear when and how the court should make a distinction between these two concepts. And the two cases that we're going to look at are the case of Ans and Merton on the one hand and Murphy and Brentwood on the other. And essentially what these cases, we've talked about Ans and Merton in more detail previously, but we'll talk about it in relation to pure economic loss in this video. And we'll talk about how this was overturned by the subsequent case, and really the trouble that the courts have had in trying to make determinations in this particular regard. So, in 1978, we have the case of Ans and Merton LBC. This case involves the claimants who had been the lessees of a block of flats. Now, the block of flats had ultimately had faulty foundations, and the faulty foundations in which they were built led to cracks in the buildings themselves. Merton LBC was the defendants, and they were sued for breach of their statutory duties. So there's generally there are tortious duties and tortious statutory duties in terms of approving building regulations and foundations, and so essentially they were sued for breaching their statutory duty in approving the foundations where it was clear that they were not deep enough to actually support the building that they were building on, and so as a result of which it was ultimately going to be the case that it would cause damage to the building, which was make it unsafe for the people who are living in the block of flats. Now, it was held by Lord Wilberforce that a two-stage test should be established for making determinations as to the existence of a duty of care in these specific circumstances. He says that the first question that you have to ask, the first stage of the test, is whether or not there is a sufficient amount of proximity or neighbourhood between the claimant and the defendant, such that the defendant should reasonably foresee their actions would likely cause damage to the claimant. That's on the one hand. And then the second question is, are there any considerations which may limit or negate the duty of care to be found? So, this was the basic duty of care test that we looked at, and when we were talking about the development of duty of care within the English law, we touched on that in previous lessons. But then in addition to this test, there was issues in relation to the establishment of the idea of pure economic loss. So not only was there conversation about the establishment of a duty of care, this case also illustrates the difficulty that is had when we talk about pure economic loss. Because in the case itself, the House of Lords used the language of, quote, material physical damage, when they were referring to the damages that the council will have to compensate in essentially finding for the claimants. And so ultimately, the House of Lords made no distinction here between physical damage to property and the defective property, which was the conditions of the flats itself. Now, essentially, this is something that's interesting when we think about the law of contract, but ultimately this case is altered, okay? And the claim for actionable damage in negligence would later be rejected by the 1991 case of Murphy and Brentwood, DC. In this case, you have a very similar set of circumstances, a very similar set of facts. Essentially, the claimant had been the purchaser of the house. The house, again, was built on poor foundations. This decision to build on said property was one which was approved by the council, so they had been negligent in making that approval, leading to the poor foundations on the property. And so when it came to the sale of the property, it was found that a significant cost would be required to restore the foundations of that property for sale. So the claimants then sued the council for negligently approving of those poor foundations in the first place, for the damages of the significant cost that would have to have been essentially instigated in order to restore those foundations to make it suitable for sale. And it was held by the courts that the position in Ans and Murden was wrong, and they rejected that position and instead concluded that this was a case where there was pure economic loss. And so it was held that because the house was built on the foundations, there was no damage to the property, given the fact that the property was always damaged. Because the property itself didn't exist until it was built, obviously, and it was only ever built on poor foundations, it was always damaged. So there was not a situation where you have a house where it is worth a certain amount of value, and then somebody through their own negligence comes in and then damages that property, which then reduces its value and then causes economic loss. That would be consequential. But what they argued was that the property was always damaged and it was always poor on poor foundations, and so there was no damage to the property that such situated and led to a situation, shall I say, where you have consequential economic loss. There was always pure economic loss, and so as a result of this, the claimant actually had no claim to be answered for.